Thank you, Mr. Chair. Sure. Thank you, colleagues. Senate Bill 1248 is before you. It was CEQA process that held up our recent floor vote on the Exide cleanup of lead matter. Once Governor Brown dropped his opposition to a CEQA review, President Pro Tem de Leon provided urgency legislation and we moved forward. My concern is with CEQA lawsuits where we don't know who the plaintiffs are. A recent headline said Kern County Citizens for Responsible Solar filed a CEQA lawsuit which held up a 150 megawatt solar power project. It turned out that this organization was deemed fake. It was formed by labor unions who were forcing the builder to sign a project labor agreement. Colleagues, CEQA was designed to ensure that the long-term protection of the environment, consistent with the provision of a decent home and suitable living environment for every Californian, shall be the guiding criterion in public decisions. It fails when even the smallest of irrelevant lawsuits with ulterior motives can delay or stop the building of homes and businesses in our communities. A recent study showed that about half of CEQA lawsuits are on taxpayer projects with no business interests. On for CEQA lawsuits targeting construction projects, 80% of them are on infill projects. Plaintiffs who challenge projects under CEQA typically file kitchen sink complaints that include every conceivable legal theory or cause of action that could provide a basis for a judge to set aside a project. In many instances, plaintiffs may organize under an umbrella group to remain anonymous in their litigation as to not be identified in the process. Your chairman, Senator Wieckowski, was just in front of my committee, Governance and Finance, working on infill projects. So this is a critical need, especially in his district. Instead of using CEQA as leverage to extort our law-abiding business community, Senate Bill 1248 would require that all involved plaintiffs and contributors be identified. The owner of private property should have the right to confront his or her accuser. Transparency is a hallmark of good government. This bill would prevent those who seek an unfair business competition advantage or have ulterior motives from improperly hiding behind a California Environmental Quality Act to block a project through litigation. Simply, this bill would require full disclosure of all participating parties in CEQA litigation and remove anonymity from those who file under the pseudonyms of unincorporated associations. This bill will also require disclosure of any party that has financially contributed to CEQA litigation, as is required in attorney fee motions and amicus filings and similar to campaign finance disclosure laws. We have transparency in those areas. This abuse impacts municipalities, as half of CEQA lawsuits target taxpayer-funded projects. The most commonly targeted are transit systems and renewable energy projects. CEQA was not planned to be a tool for bullies. Colleagues, let's discontinue a bad practice. Let's make California more business-friendly. It's about disclosure and transparency. Let's make a dent in the perception that California is too litigious. I urge a no vote. I have support from the Western Electrical Contractors Association, Associated Builders and Contractors San Diego Chapter, Air Conditioning Trade Association, and Plumbing, Heating, Cooling Contractors Association of California, and I do have witnesses in support. I urge and I vote. Thank you, Mr. Chair.
Great. Thank you. Witnesses in support, please.
Andrea Lisi, I'm managing partner with Ramey Moose Manley here in Sacramento. We're a small boutique CEQA firm. I have about 16 years of experience. We represent mainly public agencies and real parties and interests, and we do some petitioner work, so we're also considered fence sitters by some judges. I was raised in Squaw Valley. My family was part of a lawsuit against Perini Corporation in the 80s before the anti-SLAPP statute. Our family and community was sued in response. And so I think this bill, I'm here in support of this bill because I can see and appreciate all sides, but I do believe overall transparency in the CEQA statute and disclosure of who is really truly behind lawsuits would be a benefit and would make the process more efficient. I think some of the real concern is that the potential for bias in the judiciary should the judges know exactly who is behind a CEQA lawsuit. It's kind of an intellectual fiction in my mind because we should trust judges to apply the law and the merits to a particular case and not predispose themselves to their own personal bias. So that argument does not sway well with me. And I think this bill would also make it efficient in the sense that Petitioner groups going forward in the very beginning would understand and appreciate that should they not prevail on the merits, they would not get their attorney's fees on the back end. This came to light when we were involved in SEIU versus Sutter Hospital project. SEIU sued using CEQA to leverage a contract negotiation and at the time, and their dues-paying members paid out $400,000 in attorney's fees just through the trial court process. They won on one issue, sought attorney's fees, and the court denied their fees because under CCP 1021.5 of the statute, their fiscal interests were deemed to outweigh their environmental interest. So we were able to do discovery at the end and prove to the court that, their fiscal interests were outweighing. And if I'm a dues-paying member of a union, I would want to know going forward that this is a potential risk. It also would help in the sense of a TRO or preliminary injunction stage of a lawsuit and knowing if petitioners really have any capital and financial, interest to put up a bond that would offset the harm to the developer if it's in the context of a developer lawsuit. If they lose on the merits, that bond would go to offset that harm, which is fair. It levels the playing field a bit. And this happened in a Native Plant Society versus El Dorado County, where we represented a senior congregate care project, really high need for congregate care in El Dorado County, sued by Native Plant Society. Native Plant Society had revenue. Should they wanted to put up a bond, they could have posted the bond. They chose not to, so the project went forward despite the CEQA lawsuit. But we were able to, find out what their interest, and what their capital really was. And also when it comes to unincorporated associations, it's very difficult to ensure, that global settlement will actually be reached in terms of a settlement agreement and enforcing a settlement agreement. Actually who is behind the unincorporated association so that if someone breaches that agreement in the future, you know who exactly you're dealing with. So I urge support of this bill. One other last point is at the Court of Appeal level, we do have to submit disclosure forms so that judges know if they need to recuse themselves with a conflict of interest. This bill would also help trial court judges identify whether or not there's a potential conflict there, depending on who the petitioners are. So it will also help, I think, the judiciary in that respect. So urge support. Thank you.
Thank you, Kevin Dayton with Labor Issue Solutions, LLC. Since the mid-1990s, I have been tracking various actions on the California Environmental Quality Act and at the California Energy Commission to determine what the ulterior purposes are of various groups that file these actions. Many of these actions are actually related to union concerns and are used as leverage to try to pressure developers to sign project labor agreements or agree to labor neutrality agreements. And some of these organizations, to their credit, are open and they put themselves down as the name of the organization. And then some of these unions use front groups to hide their true identity. You heard an example, Kern County Citizens for Responsible Solar. It sounds great in the news media when it sounds like local citizens are objecting to a solar project that's bad for the environment, but the real truth is that was California Unions for Reliable Energy and the International Brotherhood of Electrical Workers Union. And as soon as you find that out, you say, what are they doing objecting to solar projects? There are some groups I've just never been able to figure out who they are. A couple of examples are Horizon Planet and California Clean Energy Committee. Some people say to me, oh, these are union groups. I've never been able to figure out what they are. I actually don't believe that they are, but we don't know who they are, and they've filed multiple lawsuits against various local entities claiming that their environmental impact reports are inadequate. So I would like I think that at least knowing who these groups are is an important step in keeping the public informed about CEQA and helping to keep CEQA as a credible law when people are misusing it for purposes other than environmental protection. The people should know about it and say, let's keep this with environmental protection.
Thank you for that. Others who have something to add?
Mr. Chair, members, Chris McKay on behalf of the Civil Justice Association of California. Just 2 key points. One is under the Judicial Council Rules of Court, they require disclosure both for the filing of amicus curiae briefs as well as a motion to recover attorney's fees, and also the federal courts require disclosure for filing suit under the National Environmental Quality Act. So for those reasons, we support this disclosure as well.
But isn't this a big difference? Isn't this a big difference, filing an amicus brief and putting up a challenge to a CEQA document at the front end? I mean, amicus brief is way down the legal trail. I mean,
The timing, Mr. Chair, we don't see any distinction in that timing process, and I think the primary witnesses addressed the need for the courts to know up front, not only at the later stages when an amicus brief is filed.
let's hear from other supporters, please.
In support, Tom Scott, National Federation of Independent Business.
Anthony Sampson, California Chamber of Commerce, in support.
Okay. Is there anybody here who's actually opposed to SB 1248? Please come forward at this time.
Good morning, Kyle Jones with Sierra Club, California, in strong opposition to SB 1248 today. I would kind of first want to start with disputing the problems that were listed by the author.
Excuse me, Mr. Chair, can we give them an opportunity to sit down and do their presentations?
I'm sorry. Please. Yeah. I was remiss.
Thank you, Senator. I did want to start with questioning the need for this bill and you know, some of the problems that were suggested. First, the statistic that 80% of CEQA lawsuits target infill sites that I believe comes from a report that was recently issued. That report uses a very broad definition of infill. When we think of infill, I like to think of that mixed-use development surrounded by existing structures. The infill definition used in that report cited the projects that were located within city limits or an unincorporated county adjacent to city limits. There was no specification as whether or not the area around those projects was urbanized at all. Secondly, I would think that the purpose of CEQA is to certainly allow for taxpayer-funded projects to be targeted. That was the initially when CEQA was presented, it wasn't even clear whether or not private development was available to or would fall under the act. Initially, it was taxpayer-funded projects. So we don't think that there's a problem with being able to challenge taxpayer-funded projects, and certainly think that there should be the same level of scrutiny to ensure that projects that the state or local governments are doing isn't contributing to environmental harms. We think it's important to allow people to be able to contribute to CEQA cases anonymously. Oftentimes, some of these cases can be contentious within the local community, and while someone wants to contribute to that, they might not necessarily want to become public about how they're perceived in the community. I think that what this does is it burdens local groups from having in handling their accounting, but also can prevent people from taking legitimate concerns to court and have the effect of preventing people from associating and having their rights be met. I think that the mention of the amicus is concerning. I think the purpose that I understand that the reason you do disclosure for amicus is to prevent parties from getting around briefing rules and not for something like this. And so I don't think that the problems that were associated are quite as dire as they were made out to be. And I think the solution proposed is wrong, it's overbroad, and it burdens too many people and will negatively impact the environment. We urge a no vote today. Thank you.
Mr. Chair, member Cesar Diaz on behalf of the State Building and Construction Trades Council, also in strong opposition. CEQA is a community tool. It is meant to prevent certain projects from just going out without actually the proper mitigation. It was mentioned that they are not aware, or the proponents of this bill are not aware of who's behind some of these organizations. But yet the gentleman mentioned that he actually knows who's behind the organizations because he's done some research. So it seems to us that this bill is inconsistent and unnecessary, but inconsistent with the First Amendment in particular. I mean, freedom of speech and freedom of association, this bill strikes at the heart of that. It looks to disfavor the petitioner and who is actually, and identifying them. And if you look at the community organizations, that how they're funded and their membership, if they're attacking and dividing that community, then perhaps they're going to attack the ability for that community to voice their opinion on a particular development project. We think because of that, then it's sort of like a end run on the CEQA process itself. The Supreme Court has acted and has stated that even though a petitioner has environmental and economic interest in the project, that they still have the ability to petition the court within CEQA. This bill seeks to dismantle that and then turn CEQA on its head and taint the petitioner essentially to do in favor. Now, it doesn't even, also the project developers don't have to disclose anything. So whoever the proponents are of a particular project, there could be an LLC, there could be a corporation, there's nothing on their end. We also want to note that CEQA already prevents frivolous lawsuits from coming forward. And it actually punishes a frivolous lawsuit if it meets a certain standard. So we believe this bill is unnecessary. It strikes at the First Amendment, and we strongly urge your no vote. Thank you.
Mr. Chair and members, Caitlin Vega for the California Labor Federation. We are also here in opposition. Many of the witnesses in support of this bill specifically referred to part of the problem being unions' use of the CEQA process and engagement in this process. It is our obligation on behalf of our members to defend not only their interests as workers, but their rights to safety and good health and clean air and all of that, but also their rights as members of the community. And as a local union rep, I was often a part of coalitions with other community members, with small businesses, with community members who would be impacted by various kinds of projects. That is a perfectly appropriate use of CEQA, and in fact what it was intended for communities to have a voice in these projects. The fact that a union is part of that coalition is in no way inappropriate. It is completely the purpose of that act and part of our job on behalf of our members, both as workers and as members of their communities. So we're here in strong opposition.
Kelly Doe on behalf of California Lake Conservation voters in opposition.
Others who have a comment from the public? All right, let's close that portion of the hearing. Let's bring it back to committee members who have questions of the author. Senator Gaines.
I want to thank you for bringing your bill forward, number one. And I think we clearly need some reform of CEQA. And you know, my recollection, my history of CEQA was that it's a mitigation process to make sure that environmental issues are addressed with any project that moves forward. And the intent was not to stop the project, it was to mitigate. And so I think it's grown into something much bigger over time, historically. And I guess I have a question for you in terms of, it looks like the intent of the legislation is one of transparency. And I think it would be nice to have that sense of transparency. We talk about transparency in government. We talk about transparency even in politics in terms of where is money coming from and making sure that's identified. I mean, we have to do that as elected officials. Campaigns have to do that. So it seems logical to me that going through a process, you would want to know who was in support and who was in opposition of that process. Now, maybe you could give me could clarify in terms of what the intent of the legislation is, but that's what I'm seeing in the review I'm looking at. And if it goes beyond that, please help me.
I think you've got it right.
So-
We're not changing CEQA. We're asking that there's just full disclosure when someone is suing on behalf of a project. Where our frustration has been is observing that pseudonyms are used by groups, and it's a form of green mail to accomplish something completely different than helping the environment. So I think you and I are in alignment.
Okay, great, wonderful. Thank you.
Well, I have a couple of questions, and they were brought out on the staff report, because it seems to me that this is dangerous, your proposition, because rather than focusing on the what, which is what's raised, we're focusing on the who. And the staff report points out that this is fundamentally as some of the opposition has said, is going to curb public participation because you're not, whatever they wrote is what the CEQA process is supposed to do. You have not mitigated the, on this project. How do you respond to that criticism?
I think the who is important. There was a speaker who said that you have identified all the parties that are involved, but that occurs at the conclusion of the trial. So, providing information up front prevents conflicts with judges, et cetera. I'm not a legal expert. I'm not a lawyer. I did have to pass law for one of my 4 parts of the CPA exam, but perhaps one of my witnesses would like to respond to that as well.
Andrea Lisi, I don't believe it would become a sideshow who versus what, because time is money. So real parties are typically wanting to move the process forward faster. So, yes, it may be an issue in some cases, but in the very beginning of litigation, it's more about let's get the briefing schedule and the record done and motor forward, because some, depending on financing, some projects are held up.
Yeah, but you're focusing on the petitioners, and the defendants are attacking the petitioners versus what's contained in the brief, or what's the objection was.
Well, I would only also add that there's also already an existing duty to exhaust all issues at the administrative level. So to the extent that you have an unincorporated association formed after litigation, those individuals still have to come forward during the litigation or during the administrative approval process before they can become part of an unincorporated association and file a lawsuit. So it's really just more about leveling the playing field, knowing who we're dealing with in the very beginning of initiating a lawsuit and making the process more efficient.
See, fundamentally, the state of Alabama wanted to know that 60 years ago when they wanted to know the members of the NAACP. They said, all we want to do is who's part of your organization, your association. And that's law for 60 years, is that you can't compel the names of these associations because it's going to have an effect on free speech. That's also included in the staff report, is saying this is a fundamental right that people have to associate, and this looks to dangerously curb that. I know you're not a lawyer, but it seems like the Supreme Court has said long ago that your right to associate or your right for free speech should not be hindered by us. And it looks like this is a step sort of in that direction of saying, it doesn't matter the what, it's just who you are.
Well, it seems to be very important in political contributions and filing and full disclosure. So this is a transparency issue.
Well, and I would only add, just as a practical matter, in CEQA litigation, that information is able to be disclosed through discovery at the end of the process anyway, should petitioners prevail on the merits and seek attorney's fees under 1021.5. So it's just whether or not that happens earlier in the process and versus later. And in California, I see we have the First Amendment, we have the anti-SLAPP statute against strategic lawsuits against public participation. There's also the inability to recover attorney's fees from petitioners should they lose on the merits. So there are various protections in place already for people who are interested in commenting on projects.
It's the intimidation element. It's the intimidation that by forcing people to disclose it, that we're intimidating them from make my day. Go ahead, file that suit, and that's what we're concerned with if we're really going to make the process open. The other concern that I have is this notion of frivolous lawsuits in the staff report from page 7 to 8. I'm familiar with Ms. Hernandez's work at Holland and Knight, but it looks at it breaks it down on the number of Caltrans CEQA related cases in fiscal year 11 and 12, 12 and 13, 13, 14. In 4 years, we've got 9 cases. That doesn't ring my bell as far as an abundance of cases. How do you respond to that disclosure in the staff report?
I had staff look up other cases on the internet for quite some time. Built a pretty big, thick file. El Cajon residents fear more drugs and crime, use CEQA to stop homeless transitional center for almost 15 years. I mean, I could go on and on with others, but
But it's just saying the need for the bill. If if 90% of Caltrans projects are exempt from CEQA, 8 require a negative declaration, this is a lot to do about nothing. I mean, there's perception out there in the street that, oh my God, it's horrible. But when it comes down to litigation, it's an itsy bitsy little piece of all the action. I mean, we got a page and a half here on that.
I think this bill is needed if there's only one example. The problem here is a lack of transparency to the public. People who live in the city of Dublin, seeing a group called Concerned Dublin Citizens objecting to a transit village project at their BART station, should be able to know that Concerned Dublin Citizens are reality the Carpenters Union, so that they can assess that. And in fact, if I were a member of the Carpenters Union, that local, I would be interested in being able to know that my own union is trying to stop development and ask the reason why. So I see the issue about trying to protect the privacy of the people doing this. I also believe, though, that there's a right for the public, when they see proposals in their city being objected to know who those people really are. Otherwise, the people can't make any reasonable assumptions about whether or not to support that CEQA action or not.
Seeing no other questions, why don't you close, Senator Moorlach?
Thank you, Mr. Chair. I appreciate you bringing up the word intimidation. As a supervisor, it was often, we would be told, well, if you're going to put this there, then we're going to file a CEQA lawsuit and prevent you from doing that. And here we're just seeing in California a law that is being maybe misused, definitely misused, but with using pseudonyms and then having green mail. I think that's inappropriate. Misusing CEQA is lawsuit abuse, and something needs to be done. And I think this is a simple and correct approach to take, and we've got to start moving forward on fairness in the system, and I request an aye vote.
Is there a motion, Senator Gaines? Senator Bates moves. Yeah, I'm concerned about that. How it infringes. Let's open up the roll call. Please call the roll.
Item 15, SB 1248 by Senator Moorlach. The motion is due pass and referred to Committee on Judiciary. Senators Wykowski?
No.
Wykowski, no. Gaines? Aye. Gaines, aye. Bates? Aye. Bates, aye. Hill? No. Hill, no. Jackson? No. Jackson, no. Leno? No. Leno, no. Pavley?
We have one missing member. We'll keep the roll call open. You have insufficient votes at this time.
Thank you, Mr. Chair.
Okay.